something interesting happens before we get to Planned Parenthood v. Casey in 1992. Anti-abortion groups in the intervening years became exceedingly ecstatic when two liberals on the court, Brennan and Marshall, who had long been supporters of abortion rights, retired after Webster. These retirements gave President Bush the ability to appoint two anti-abortion justices. And the two individuals that Bush ended up appointing were Justices Souter and Justice Thomas. Recall that in Webster, potentially 4 justices, including Justice Rehnquist, Justice Wright, Justice Scalia, and Justice Kennedy, all seemed ready to overrule Roe. And now there's 2 more justices on the court appointed by a conservative president, Justices Souter and Justice Thomas. So it seemed to many activists at the time that Roe v. Wade was done. While Justice O'Connor in Webster had not been the decisive vote to end Roe v. Wade, now it seemed that Justice O'Connor was not at all needed, because the 4 justices in Webster who were willing to overturn Roe were now going to be joined by 2 Bush appointees, and that would easily give them a majority. And so policy groups brought forward again more limitations upon the right of woman's choice in Planned Parenthood v. Casey. And the decision in Planned Parenthood v. Casey does not go the way that anti-abortion groups thought it would. So in Planned Parenthood v. Casey, there exists no opinion that carries a majority vote of the court. There is, however, a circumstance by which 5 justices agree on a few central principles going forward. Justices O'Connor, Justice Kennedy, and Justice Souter write a plurality opinion which limits Roe v. Wade, but didn't seek to overrule it. So Justice O'Connor, Justice Kennedy, and Justice Souter, all 3 Republican-appointed judges, write a plurality opinion that limits Roe v. Wade, but absolutely does not overrule it. Those 3 justices were joined by Justice Stevens and Justice Blackmun, Blackmun being the original author of Roe v. Wade, to form a majority outcome of 5. And so there do exist 5 in terms of this case, but those 5 don't agree, so there exists no majority opinion. But there exist 5 judges who agreed on not overruling Roe v. Wade's determination that there existed an inherent right of privacy to have an abortion. So despite all of these appointments by Republican judges, still 5 justices agreed to not overruling Roe. They disagreed with regard to what limitations could be put in place. But the 5 of them agreed that Roe v. Wade was not to be overturned. So in this particular case, Pennsylvania passed a law which limited availability of abortions. They didn't outlaw it, but they made it more difficult to obtain an abortion. The methods by which they did that was requiring informed consent prior to the abortion, along with a 24-hour waiting period before the procedure took place. It required minors to obtain informed consent of at least one of their parents. It required women notify their husbands, and placed certain restrictions on facilities that were to provide abortion. So the court in this case overruled some of those restrictions, or overturned some of those restrictions and upheld some of those restrictions. O'Connor's opinion is really well written. She absolutely confronts the question that everyone was expecting to be asked and answered in Planned Parenthood when she writes that liberty holds no refuge in a jurisprudence of doubt. Yet 19 years after our holding that the Constitution protects a woman's right to terminate her pregnancy in its early stages, that definition of liberty is still questioned. She continues on. After considering the fundamental constitutional questions resolved by Roe, principles of institutional integrity, and the rule of stare decisis, we are led to conclude this: the essential holding of Roe v. Wade shall be retained and once again reaffirmed. So she wastes absolutely no time getting to the point. Roe v. Wade's still good law, and a majority of us agree with it. And we've considered everything. And also, you all should stop doubting when the court says something that it actually means it. When we said that women retain the right to terminate a pregnancy at its early stages, and we said that almost 20 years ago, we still mean it now. So good writing on behalf of Justice O'Connor. They do ultimately allow some of the prohibitions from Pennsylvania to actually go forward.
These came back from a search.
And that's my phone making noises for some weird reason. Apologize for that. So, what prohibitions went forward in this case? Well, first off, the standard by which she determines what prohibitions go forward is not the trimester framework, but instead the standard that she articulated in her dissent back in 1983, and that's the undue burden standard. That if the regulations in question provided an undue burden to a woman's fundamental right to receive an abortion, then they had to be declared unconstitutional. Neither the informed consent nor the 24-hour waiting period were determined to be unconstitutional. The court also allowed placental consent to go forward as long as there existed a judicial procedure by which to bypass it. That meaning that if there was a good reason to not allow parents to control the outcome of this, there existed a method by which the individual wishing an abortion could go through the courts to actually bypass the parental approval. However, one provision was struck down. The provision regarding special notification was declared unconstitutional. And Justice O'Connor uses statistics to demonstrate why this was an undue burden. She showed that 1/5 to 1/30 of women are physically assaulted by their husbands at some point during their lives, and thus it is absolutely unreasonable to require women to notify their spouses that they mean to terminate what possibly was the result of such abuse. And so they do strike down the parental, or not the parental notification, but the spousal notification requirement. All of the requirements towards the facilities were deemed unconstitutional as not being undue burden, except one. It required a woman to obtain the consent of her husband, as I just said, sorry, reading my notes and skipped over that one. So it's a plurality decision. Most of the regulations that Pennsylvania put forward were deemed constitutional, but Roe still stands. Justice Stevens wrote a concurrence in which he concurs with all parts of the decision, except he dissents regarding the informed consent and 24-hour waiting period. He said he would have kept those, he would have struck those down as invalid. Justice Blackmun concurred in part and dissented in part. Justice Blackmun is the original author of the Roe v. Wade decision. And so he was naturally fairly protective of that decision. So while he agrees with much of the reason that Justice O'Connor writes in the plurality, he absolutely disagreed with the part that neutered his trimester framework approach. So he was a little bit protecting um, his own precedent. Um, so who are the four dissenters? What do the four dissenters say? The main dissent was written by Chief Justice Rehnquist, who was joined by Justice White. Remember, the two of them originally dissented in Roe v. Wade together, or not together, but separately. They're also joined along with Justice Scalia and Justice Thomas. The dissenters are not happy. The joint opinion, following its newly minted variation on stare decisis, retains the outer shell of Roe, but beats a wholesale retreat from the substance of that case. We believe that Roe was wrongly decided and that it can and should be overruled. So their argument is that you didn't engage in stare decisis, despite the fact you articulated it. You significantly modified Roe v. Wade. That's not stare decisis. That's not following previous precedent. And if you're not going to do that, you might as well overrule the whole thing because we think it's wrongly decided because it uses substantive due process. So where does this ultimately leave us? This leaves us with a court that has gone through a significant amount of ideological evolution. From the 1950s to the 60s, to the 70s, to the 80s, and now to the 90s, we've seen a court that has ideologically changed in significant ways. But the foundation of that privacy-based right that was articulated in Griswold is still controlling the majority outcome of the court in 1992. And so substantive due process is still in vogue because you have to remember a majority of the court in Planned Parenthood are defending that substantive due process right as articulated in Griswold and as articulated in Roe v. Wade. So in the next class, we'll talk about more abortion rights going forward, more cases going forward, and what the evolution of substantive due process looks like in other areas of the law.